Intro to Criminal Justice, CJ 1100. Today I'm wearing a hat because we've been having some crazy rainy weather up here in Boone. I bet most of you aren't up here. It's been raining nonstop for like 5 days. Bad hair day. So this is a quick presentation about the law. Now, you're supposed to be doing these readings in the book that's written by Dr. Holcomb and Dr. Williams of our department, plus others in the co-authored book. But there's also the PowerPoint slideshows are online that deal with the readings in case you don't have the book, but also to supplement it. And so the first set of PowerPoints dealt with criminal versus juvenile justice, which I made a video about the first time. So this is video number 2. And I'm just going to talk briefly about the law and hit some of the main points rather than going through all of it. First of all, the law itself is a set of rules that governs how we're supposed to behave. And it specifies things that we can't do, like murder or theft. But it also specifies things we must do, like pay child support, pay taxes, for example. And then it sets forth punishments for failing to do that if you break the law. But it also specifies rules that you have to follow, that the courts have to follow and the police have to follow and correctional facilities have to follow when carrying out the law. And that's called due process. So there are laws at the local government, there are laws at the county government, there are laws at the state government, there are laws at the federal government, etc. Lots of crimes out there. One lesson you should know as an intro student, most crimes are crimes against state government. So you have a lot more people incarcerated in state prisons than you do federal prisons for that reason, because there's a lot more laws by states. And there's also 50 states, right? That's another key point you should remember going forward if you major in criminal justice or if you work in criminal justice. But also you should know it as a voting member of society. A crime is an act against the government, not you, not your family. Even though you're considered the victim, your rights are quite limited, in fact. The reason the state has the right to arrest someone, investigate someone, convict someone, punish someone, is because they're the victim. So they're acting on your behalf as a crime victim. As the actual legal victim is the state, which is why they can incarcerate you and in the most extreme cases actually execute you, take your life. So just keep that in mind going forward. You'll see in the slideshow that most of our laws come from England, and so there's a term called common law, which I mentioned, I believe, in the first video, which is law from tradition, from English law, from courts that we brought over. I'll speak about one of those when we get to the courts and a problem with trials that I will refer to that actually just comes from English common law, and I think we should actually abolish it. This is called removing someone from a jury without reason. These are called peremptory challenges. I'll get to that much later in the class. Okay. You'll see that when laws are written, they form a precedent. This is something that must be upheld by other courts. Now, the Supreme Court does routinely overturn its own precedents. A couple examples. In the 1980s, the Supreme Court said it was unconstitutional to execute a juvenile. That was later overturned. They said, I got that backwards. They said it was okay to execute a juvenile in the 1980s, but then said it was no longer constitutional in the 2000s. They also said it was constitutional, permissible, to execute someone with a low IQ or what we used to call mental retardation, and then that was overturned in the 2000s as well. But generally speaking, a precedent is meant to be upheld by other courts. That's why the rule of law stays in place, because courts follow the precedents of other courts. Now, in terms of your sources of the criminal law, you'll see this in your PowerPoint presentation starting on slide number 6, if you open this. The first is the Constitution. The Constitution is the highest source of law in the United States. It also includes, by the way, if you read the Constitution, the supreme law of the land includes not just the Constitution, but also any treaty that we ratify. So we're not supposed to be violating treaties either that we ratify. But the Constitution is the highest source of law in the land. It outlines the structure of our government, so it tells what the House is and the Senate and the presidency and the courts and all of their rules and responsibilities. But it's considered the highest source of law, and any law that comes from that is called constitutional law. Okay. You also have executive laws. These are laws of executives. So mayors, governors, presidents. You can look at President Trump's executive orders as an example, as examples of executive law. Judicial law comes from the courts, as you might guess, and the term that we use in criminal justice and when you take your courts class is called case law. So courts interpret the law when it's confusing in order to tell us what it means. That's considered case law, and they'll satisfy disagreements between two parties. The Supreme Court, of course, has the final say on these matters. If a case goes all the way to the Supreme Court, what the Supreme Court says is final. That's case law. Now, the rest of the law is called statutory law, and statutory law comes from statutes. This is laws of the state and laws of Congress. And you'll see the way that it's presented in your PowerPoint presentation is substantive and procedural law. Substantive law is the substance of the law. It's the what of the law. So one way to remember this term is just look for the term substantive and substance, right? Whereas the other type is procedural law, which specifies the procedures of the law. It's an easy way to remember it. The substantive law includes civil and criminal law. If you want to see civil law, one party versus another, suing for wrongdoing, watch Judge Judy, People's Court, that sort of thing. The purpose there is not punishment, but it's restitution to the victim. Someone steals your property, damages your property, you sue them, and you get restitution, get money. The criminal law, however, deals with an act against the government again. So it's a crime committed by a person or a group of people against the state or the federal government, and the purpose there is punishment, not necessary restitution to the victim, but rather punishment in the form of probation or jail or prison, depending upon the type of crime. Okay. The principle of legality states that the government cannot punish an individual unless the act is defined as a crime. So something has to be defined as a crime before you do it. There's a famous case in Florida of a man who killed his mother with the help of his friend. These are young men, like teenagers. And before they dumped the body in the well, the friend actually asked the son if he could have sex with the mother. Now the woman was dead. This is called necrophilia. And of course the son was freaked out and grossed out, so he just left. But apparently the friend engaged in sexual relations with the body, called necrophilia. They discovered this when they found the body, and they determined that this had happened through an autopsy. Well, here's the thing: necrophilia was not a crime in the state of Florida. So as disgusting as it was, they could not hold him accountable for that act. Now he was accused of murder and found liable for that. Both of them were. But they couldn't add on any time or any punishment for the act of necrophilia because the principle of legality, it was not illegal at the time. Now, the legislature had a special session. They came together. They made it a crime. So in the future, if anyone does it, it's actually a crime. But that's what the principle means. In terms of what the crime includes, you have, number one, the actus reus. This is the act itself. So for example, in murder, the act is taking a life. In the crime of theft, it's the act of taking someone's property without their permission, right? In the act of arson, in the crime of arson, the act is maliciously burning someone's property. Okay, it includes acts, it includes attempts to act, it also includes omissions of acts of omission, or failures to act, like not paying your taxes or not paying child support if it's ordered by a court. Okay, and if you agree to act, that's called a conspiracy. Two or more people enter an agreement to act. So even if you don't carry out the act, that's still a crime. Okay. Now legally, you generally have to take one step towards that act. So if you conspire to kill someone and then you go out and buy a gun, or if you put it on paper, this is an act that would satisfy the crime of conspiracy. Okay. The mens rea, the other legal term, or Latin term, refers to a guilty mind. This is the mental act. So not only do you have to commit the act, but you have to knowingly do it, or intentionally do it, or negligently do it, or recklessly do it. You have to have the intent. You have to have the mental guilty mind in order to be convicted of a crime. Now there are some crimes called strict liability offenses that do not require mens rea or intent. This is if you commit the act, you are liable for it. Okay. The example given in your slide is statutory rape. Statutory rape is not necessarily an act of aggression or an act of violence. It would be two people willingly consent to have sex, but one of them's not old enough. If you sleep with someone who's not old enough by law, and so the age of consent in North Carolina is 16 years, okay? If you sleep with someone below that age, you are liable no matter what, even if you didn't know. That person could have a fake ID, a fake birth certificate, whatever. The point is you are liable if you do it. That's a strict liability offense, okay? Speeding's another case, although it's not a crime, it's just a violation. You're liable if you do it, period. Now you also, the prosecution, if they're going to convict you of a crime, has to prove causality, causation. This means that your act led to either the direct cause, the direct harm, or the proximate cause of it. So you started a series of events that led to a death. So for example, you might not know this, but with something like capital murder, if you commit a capital crime, if you commit a felony, like robbery, and someone dies, that's a capital crime, that's a capital murder, even if you didn't intend for someone to die or mean to. So a real case out of Florida, and I mention Florida a lot because that's where I'm from, but a case out of Florida was a young woman, probably in her early 20s. She helped set up a robbery. She lured someone to the scene, and her boyfriend was one of the robbers. So she just got this guy to come thinking he was going to have sex or meet someone exciting or whatever. And the boyfriend and his friends killed this guy. Well, she was found guilty of felony murder, which is a capital murder in the state of Florida, and it is in most places too, like North Carolina. So just by setting up a robbery where someone died, she was guilty of that crime because she set it up, and also she was the proximate cause of the person's death. If you rob a bank and you're speeding out of there and your tire blows, and an older person's walking down the street and have a heart attack, you're responsible for that death because you committed a felony. So that's what that means with the proximate cause. Now, in terms of types of crimes, you have crimes against a person. These are generally violent crimes: murder, rape, aggravated assault, assault, kidnapping. And you also have, and those are, as I mentioned when I say aggravated assault and simple assault, there's varying degrees. So aggravated assault means you intend to inflict severe bodily harm using a weapon or something like that. Assault, maybe just a fist fight, okay? Then you have crimes against property. These are still crimes against you, but they're called property crimes because they affect your property. So theft, burglary, arson, motor vehicle theft are examples of these. And they also vary by degree as well. And the degree is the amount of severity of it, basically. Then you have crimes against public order. These are considered victimless crimes. Victimless, don't be misled. It doesn't mean there's no victim. It doesn't mean there's no harm. Generally, it means that the victim is a willing participant, or the person who's harmed is willingly participating. So drug use is an example. Prostitution is another one. Disorderly conduct, vagrancy. It also includes weapons violations, and immigration violations are considered public order offenses. Okay. Drug offenses are also discussed in the PowerPoint presentation. If you're interested in that, I would suggest that you take my drug war class, which is an elective that I offer every few years or so. Dr. Renee Sherlin and I from our department, who's a political scientist, we've written a couple books on the drug war. We actually debated the chief scientist from the White House, the Office of National Drug Control Policy's chief scientific analyst. We debated them about the effectiveness of the drug war based on our book. And what we found was that the White House, not this White House, but every White House, was lying with data saying the drug war is going well when it really wasn't. The PowerPoint slideshow also identifies white-collar crimes, but it leaves out corporate crimes. White-collar crimes are crimes committed by people of a higher socioeconomic status. So think of a white collar, someone at work. So if you steal money from your employer, that's white-collar crime. Let's say you're a cashier and you're stealing money, or you're the accountant for a corporation or something like that. You have legal access to their money, but you're not supposed to take it. If you do, that's called embezzlement, which is a form of theft. That's a white-collar crime. But also, corporate crime is a crime by the actual corporation itself. So a board of directors decides to manufacture a defective product. Or more likely, they discover that a product is defective and they don't fix it, they don't tell anyone, which is required by law. Corporation manufactures the product and they find out it's defective. They're required by law to fix it and to tell the government and the public about it. If they don't, that's a corporate crime. You'll see later in the class, corporate and white-collar crimes are far more dangerous than street crime, which is pretty hard to believe, but this is an important lesson for an intro class and for criminal justice majors. White-collar and corporate crime is more dangerous, more deadly, more costly financially than all the street crimes that we go after and fill our prisons with. Interesting. Now, perhaps the reason we don't go after the white-collar and corporate criminals is because of who makes the law. So you have an assignment to look at who makes the law. You'll see this on your As You Learn page. And compare them with average citizens, and you'll see they don't look the same. So it raises the possibility that lawmakers don't actually serve our interests if we're just going after street criminals but not white-collar and corporate criminals. It could be because of who makes the law. So take a look at that. Now you have a section on defenses to criminal liability. These are things that you can offer as a defense, even in some cases when you intentionally commit a crime. You might have a valid justification, so like necessity. You break into someone's house in the middle of a winter, they're not home, you're going to freeze to death, so you have to do it. That's called necessity. If someone forces you, puts a gun to your head and says do this, that's called coercion. These are valid defenses to crimes. Involuntary intoxication, someone gets you drunk. Immaturity, you're not old enough. That's specified by state statute, by the way, in terms of how old you have to be held accountable. But you can look at these legal excuses in terms of criminal liability. And then there's a discussion just about some recent changes, not necessarily particularly that important, but you might be interested in some of these. And my advice to you as a professor is if any of this stuff interests you more than others, Google it, search it, find information and read about it. Because especially if you're going to work in criminal justice, these are things that might very well be of interest to you. One of the things that's really interesting to me is some of the changes to the criminal law after September 11th attacks. And I realize you guys were really young when that happened. I was a professor at App when that happened, fairly new in my job, but I've been here 4 years when that happened. So that was like 19 years ago. But the government created a Department of Homeland Security after that. They passed the USA Patriot Act after that. And of course, they carried out enhanced interrogation or torture after that. They invaded Afghanistan, they invaded Iraq. A lot had happened, right? But in terms of the law, check out the USA Patriot Act. It's very, very, very controversial. If you know what the Fourth Amendment is, and you should, Fourth Amendment gives you the right to privacy in your home, requires the government to have a warrant to enter your home or to seize you or your property. That has been very, very, very weakened by the USA Patriot Act. The Patriot Act gives the government the authority to access, quote unquote, any tangible item using a warrant from a top secret court in New York called the FISA Court, Foreign Intelligence Surveillance Court. So if you're interested in that, check it out. That's a really interesting recent change to the criminal law as well. All right. Now I'll stop there. There's also a section on procedural law, and remember what I said earlier. The procedural law is simply the procedures that the government must follow in order to carry out criminal justice. So you have some, well, the most famous one is the Bill of Rights. So your rights must be protected. Your due process rights must be upheld by the courts in order to be tried, in order to be convicted, in order to be incarcerated. If you don't know what those terms mean, ex post facto law, bills of attainder, habeas corpus, that sort of thing. Very simple. Just search them online, Google them, and you'll find a really good definition. But for the most part, procedural law deals with the procedures that criminal justice agents must follow in order to carry out the law. All right, I will stop there. I would advise you to study the Bill of Rights. I would advise you to know your rights. What I always tell students is that if you don't know your rights, they're a lot easier to take away. You know all about the Second Amendment. Everyone talks about the Second Amendment, but rarely people talk about the First Amendment, or the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, which all deal with very, very important rights of due process and civil liberties in the courts. So take a look at those, memorize those. You will be asked about them. But more importantly, you should know them as an American citizen, as a voter. But I'll stop there. Remember, if you have questions, reach out to me. If you want to do an individual Zoom session, reach out to me. Please talk about this stuff on the student forum. You You guys can interact with each other, ask each other questions and that sort of thing. I'll be there observing and making comments as well if you're there. And I'll see you guys next week. Good luck.